Today's topic addresses some of what you need to know about your information governance obligations under the Health Insurance Portability and Accountability Act of 1996 or HIPAA. Let's go.
The Health Insurance Portability and Accountability Act of 1996 is a United States federal statute that was created primarily to modernize the flow of healthcare information. The Act details how personally identifiable information maintained by the healthcare and healthcare insurance industry should be protected from fraud and theft, and addresses limitations on healthcare insurance coverage. The Act consists of 5 titles. Title I of HIPAA protects health insurance coverage for workers and their families when they change or lose their jobs. Title II, also known as the Administrative Simplification Provisions, requires the establishment of national standards for electronic healthcare transactions and national identifiers for providers, health insurance plans, and employers. Title III sets guidelines for pre-tax medical spending accounts, Title IV sets guidelines for group health plans, and Title V governs company-owned life insurance policies. Our next question is who is subject to HIPAA? Generally, HIPAA applies to covered entities and business associates. Covered entities include healthcare providers that transmit information in an electronic form in connection with a transaction for which the Department of Health and Human Services has adopted a standard. They also include health plans and healthcare clearinghouses. In contrast, business associates perform certain functions or acts involving the use or disclosure of protected health information on behalf of, or provide services to, a covered entity. Examples of covered entities include healthcare providers such as doctors, clinics, psychologists, dentists, chiropractors, nursing homes and pharmacies, health plans such as health insurance companies, health maintenance organizations, company health plans and government programs that pay for health care, and healthcare clearinghouses, or entities that process non-standard health information that they receive from another entity into a standard such as standard electronic format or data content.
Examples of business associates include third-party administrators that assist health plans with claims processing, attorneys, consultants and accounting firms that provide legal services to health plans that involve access to protected health information. They also include IT service providers that translate claims from a non-standard format into a standard transaction and that forward the processed transactions to payers, as well as medical transcription services, and pharmacy benefits managers. The next topic that we are going to address is: what is the HIPAA Privacy Rule?
The HIPAA Privacy Rule was first enacted in 2002 with the goal of protecting the confidentiality of patients and their healthcare information, while enabling the flow of patient healthcare information when it is needed, also known as the Standards for Privacy of Individually Identifiable Health Information. The HIPAA Privacy Rule regulates who can have access to protected health information, when it can be used, and to whom it can be disclosed. The Privacy Rule applies to both healthcare organizations and to entities with access to personal information about a patient that, if it were disclosed to third party, could present a risk of harm to the patient's finances or reputation, or be used by the third party to fraudulently obtain health care. HIPAA's privacy rule does not stipulate how long medical records should be retained. This means that there is no official HIPAA medical record retention period.
In addition, each state has its own laws which cover the retention of medical records, and there is no nationwide standard. There is also a great variation on what is deemed an acceptable period of time to retain medical records, not only between states, but within states, for different types of healthcare providers.
For example, Florida requires physicians to retain medical records after the last patient contact, but hospitals must retain them for 7 years. However, North Carolina requires hospitals to retain a patient's records for much longer periods of time. 11 years since the patient was discharged, or until the patient is 30 if they were admitted as a minor.
Our team at Knowledge Preservation can help you to navigate the regulatory requirements that you need in order to make sure that you are in compliance not only with HIPAA, but with applicable state laws, as well.
Contact our team of experienced information governance professionals today.